Cher public, la dernière affaire devant être délibérée au cours de cette séance publique est l'affaire numéro 001-2020. Les parties Alfred Agbesi Woyome contre République du Ghana. L'arrêt sera lu par l'honorable juge Shizumila.
Thank you, Honorable President. The court, composed of Sylvain Ore, President, Ben Kioko, Vice President, Rafa Ben Ashu, Angelo Matuse, Susan Menge, M. Teresa Mukamulisa, Tujilane Chizumila, Chafika Ben Saula, Blaise Chikaya, Stella Anukam, Iman Abud, judges, and Robert Eno, registrar. After deliberation, renders the following judgment. The parties, Mr. Alfred Agbesi Woyome, herein referred to as the applicant, is a national of the Republic of Ghana. He is also a prominent businessman, a board chairman, and director in 3 companies, namely Waterville Holding, BVI Company, Ostro Investment Company, and M. Powerpack GMB Company. The respondent state is the Republic of Ghana, which became a party to the African Charter on Human and People's Rights, herein after referred to as the Charter, on 1 March 1989, and to the Protocol to the African Charter on Human and People's Rights on the establishment of the African Court on Human and People's Rights, herein referred to as the Protocol, on 16 August 2005. It also deposited on 10 March 2011 the declaration under Article 34(6) of the Protocol, through which it accepts the jurisdiction of the court to receive cases from individuals and non-governmental organizations. Subject matter of the application. On 4 March 2020, the applicant filed an application for review of the court's judgment, herein after referred to as initial judgment, in the matter of Alfred Agbesi Woyome versus Republic of Ghana. The application contained a request for provisional measures to stay the auction and sale of the applicant's properties pending the determination of the application for review. According to the applicant, on or about 9 January 2020, he discovered information that was not in his knowledge at the time of the delivery of the initial judgment, which affects the basis of the Supreme Court decision dated 29 July 2014. Furthermore, he submits that the information relates to another agreement between the government of Ghana and Shanghai Construction Group for the construction of 2 stadia at Tamale and Sekondi, which he claims proves that the respondent state violated his rights protected under Articles 2 and 3 of the Charter. A brief background of the matter. By the initial application number 001 of 2017, filed on 16 January 2017, the applicant alleged that he was denied justice in the Supreme Court of the respondent state in violation of his rights protected under the Charter. According to the applicant, the translation of the judicial process by the review bench of the Supreme Court of the respondent state and its assumption of jurisdiction in his case violated his rights to have his cause heard and to non-discrimination protected under the Charter. He also alleged that the review bench, as constituted, was impartial and that the comments of one of the judges displayed bias. On 28 June 2019, the court rendered the judgment on the initial application, wherein it held that the respondent state did not violate his rights protected under the Charter. The court, therefore, dismissed the applicant's initial application. The initial judgment is the subject of this review. Prayers of the parties. The applicant prays the court to review its judgment of 28 June 2019 and find that the Republic of Ghana violated his rights to non-discrimination, equality before the law, and equal protection of the law guaranteed by Articles 2 and 3 of the African Charter. Issue an order for provisional measures in the interest of justice for the respondent state to cease auctioning and selling off his property in order to forestall any irreparable damages to him. The respondent state did not file its response to the prayers of the applicant. Jurisdiction. In dealing with any application filed before it, the court must conduct a preliminary examination of its jurisdiction pursuant to Articles 3 and 5 of the protocol. Rule 26.1 of the rules provides, pursuant to the protocol, the court shall have jurisdiction, to review its own judgment in light of new evidence in conformity with Rule 67 of these rules. In the instant case, the court notes that the application herein is for review of its own judgment in light of alleged new evidence and thus finds that it has jurisdiction. On the request for provisional measures, the court considers it desirable to determine both the request for provisional measures and the application for review in the same decision. The court will first consider the application for review and later decide on the request for provisional measures. Admissibility of the application for review. The court finds that the supporting document adduced herein is neither new nor evidence as contemplated by Article 28.3 of the protocol and Rule 67.1 of the rules. In the light of the foregoing, the court finds that the supporting documents adduced do not constitute new evidence which was not within the knowledge of the applicant at the time the initial judgment was delivered, as contemplated by Article 28.3 of the protocol and Rule 67.1 of the rules. Therefore, the court dismisses the application for review and declares it inadmissible. As regards the request for provisional measures, the court holds that, having found the application for review inadmissible, the request for those measures is moot. Operative part. For these reasons, the court unanimously, 1, declares that the supporting documents submitted by the applicant do not constitute new evidence. 2, declares that the application for review of the judgment of 28 June 2019 is inadmissible and is dismissed. 3, declares that the request for provisional measures is moot. 4, decides that each party shall bear its own costs. This judgment is signed by all the judges I mentioned before, done at Arusha this 26th day of June in the year 2020 in English and French, the English text being authoritative. That's the end of this judgment. Thank you.